coming to me easily. Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret.
That is different.
Money coming to
And kind of think that men are struggling with the attention that women are getting because men have to do a little bit more to get attention from women. It's sort of like this competition, you know, who's getting more attention, men or women. As long as you had a good job and you were a man that had some type of attention, you can get a whole lot from women. So these are just some of the things that I possibly could be struggling with as it relates to women as well.
Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret. This money coming to me easily. Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret. This money coming to me easily. Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret. This money coming to me easily. Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret. This money coming to me easily. Money coming in and needing me.
Ryan and what's in your car?
Repeatedly. Money coming, this is money coming. This is money coming to me frequently. Money coming in to be with me. Money coming in a secret. This money coming to me easily. Money coming in and needing me. Money coming in repeatedly.
Bullshit.
Money coming, this is money
Brian.
coming. This
It's
is
not
money
terrible.
coming to
And
me
then this is
frequently.
Bullshit.
Money coming in to be with me. Money
I
coming
got
in a
Starbucks. I got
this money coming to me
a
easily. Money coming in and needing me. Money coming in repeatedly. Money coming, this is money coming. This is money coming to me frequently.
Ryan, Diego, you didn't sound like Ryan. You just sounded like Diego.
That's what I said. It's hard.
Gay Southern accent.
No, you don't have a gay Southern accent.
I sound more like a woman than most gays.
No, you don't. No, you don't. Plus, didn't we have this conversation about his real voice versus his, like...
Yeah.
This is my real voice.
Somebody told me, it was actually Shamila. She said that Ryan used to be in rooms and he sounded normal, and then one day he started sounding more gay.
He doesn't know what she's talking about.
Ryan, let's do an experiment. Pretend you're a British lord and tell us what you're going to do this afternoon.
Well, after my ride out into the country, I think I'm going to have a glass of tea.
So the point is, you can change your voice.
Yeah, you can change it, but if you don't want to put any effort out and you
Ryan.
speak, this is what comes out.
Well, I'm just saying, thanks for participating in my experiment, and I've proven my point. Thank you very little.
I can't do a British accent. Wayla, what the heck was I going to say to you? I cannot identify a gay British accent or a black British accent. I cannot tell the difference. Yeah, like Horatio, I can't tell that it's a gay British accent. Like I cannot discern between what they're supposed to sound like. I have no idea.
Okay, Ryan, let's try another experiment. Pretend you're like an American truck driver, a 40-year-old fat guy with a deep voice, driving down the highway, screaming at another car, road rage, and screaming at people on Clownhouse. Go ahead, Abuelo. Try your deep heterosexual man voice. Go ahead.
Hello?
But give us an actual sentence, not a moan.
I don't know. I don't want to do that.
Well, there you go. See, you're too connected to your identity through your voice. It's an experiment. But I haven't.
What identity should I be connected to?
I'm just look at it as if you're an actor in a high school drama, and you have to perform a character on the stage. That's all I'm at. Like if I were to give you the script.
I don't
But
do that.
music.
I'm not
But
Well, I know you don't do that. You're
Diego
not doing it right now. You refuse to do the experiment. It's fine.
But music.
But you
Diego
did the
does a
gay
really
British
good Simon.
voice, so that's fine. So, oh, really? Go ahead, Diego.
He does a really good Simon voice.
I don't even know if I'm doing it right.
No, it sounds just like.
Oh my fucking god! No, I just.
That's it. That's good.
Oh my fucking. Holy shit! Holy
No,
shit!
especially when you said no, when you answered like the question, but when you did it like soft spoken, like low, or not soft spoken, but low.
Yeah. You remember when I described him? I always feel like at night when he's trying to be quiet, and apparently he's got a fucking 5-bedroom house, but he always has to be quiet in his house. Isn't that a little suspect? You know? And it always sounds like he's sitting on the toilet, like waiting for the big load to come out. No, like he's been.
Absolute. I think maybe up to $1 million. Could have been $1 million. It's still absolutely tragic. How do you know about Armenian genocide was the situation? I don't know how many people killed there. I have no idea how many were killed there either. I just think it's too hard to know these things. I think the gas chambers. I think the gas chambers were made up with a lot of evidence for it. They were all reconstructed. Everyone look this up. They were all reconstructed after the war. There's none of this. You know what exactly? There's no cyclone. Can I talk? There's no cyclone B residue on the gas chambers, but there are going to be lousy chambers. Cyclone blue is used for the lousy. The cyclone blue is not in the gas chambers, therefore it's impossible. That
Music. Do you know about Mega Upload?
Yeah, Kim.com. I know all about it.
Mega what? Mega upload.
Yeah,
When I need to send my graph files across the globe.
it's like, yeah. I mean, I've watched a lot of free movies through Putlocker, but it's been so long since I've had a desire to like watch a movie. And when I was watching them on my laptop, they were so shitty. Well, yeah, but the thing is, you're being cheap and watching a new movie for free, but still wasting your time. But when I'm a filmmaker, I've made over 60,000 YouTube films, and so when you start creating film yourself, you realize, well, you know, everything.
You want to get back to the artist, right? You want to pay for it.
No, you realize that what you create is so much more interesting and intelligent than all the stupid shit you've ever wasted your time watching, you know. But
that's amazing.
But books are the most interesting thing.
Diego's a filmmaker too. You should collaborate.
Well, I know a lot of people say they're filmmakers, but I can actually show you my films. Diego can't actually show you anything.
Can you show us one of your films?
The only thing you've ever seen with me, Nuno, was where I played that gay guy in a commercial for Budweiser.
Well, I've seen your presentation, you know, when you were talking about whatever you were talking about. I guess praxeology. You've seen Princessa. You've seen his. You've seen Diego's presentation on praxeology, right?
I don't know. Have I?
You haven't seen his seminar where he like got up and spoke for 20, 30 minutes about language and communication. I mean, he's a chiropractor, but anyways, you get the point.
You know, I think I'm very lucky that you don't know my other YouTube channels. I'm very fortunate. I never cross-pollinated them. I don't know what you would believe.
I'm sure Ryan has found them.
Through Bussy.
Has found his YouTube channel? Yeah, I have seen them.
All of them?
Mm-hmm. I'm subscribed.
There you go.
No, I'm saying my other YouTube channel.
Oh, I don't know about that other one.
When they started shadow banning me on that one, that's when I realized that I should not cross-pollinate. You know? Just once they shadow ban you on one. Hey, why do Instagram girls always have a backup account?
In case they get banned or just to make more money. I don't know.
Yeah. No way.
So they can actually use it?
I think that if it's pornographic, they could get banned.
Historic, what we're talking about.
I think that's what it is.
Very moment.
Hello, everybody.
My favorite ones are the guys that have their
History. You have to do something that's
on
extraordinary.
And with me
And it has
is
to be
David
recorded.
Ramsey Steele.
So, we're always moving in real time. And my
No. What do you?
I'm an editor for a publishing company,
Oh, really?
but I've written a number of books.
Have you ever had a professorship of any kind?
Only in the broadest
And
possible
that was
sense.
Okay.
it's evident.
It's supposed to be.
That was
don't mind,
Ryan
maybe you can
Evidence.
tell us some of the books that you've written.
That
You know.
Oh, well, recently I wrote with Michael Edelstein and Richard Kuyoff the book Therapy Breakthrough.
Okay.
Like some psychotherapists work better than others. Before that, I wrote a book called Atheism Explained, From Folly to Philosophy. And also I wrote with Michael Edelstein another book on psychotherapy called 3-Minute Therapy. Those are my main works, apart from the book I wrote in 1990, or published in 1992, From Marx to Mises, where I discussed Mises's economic calculation argument against the ability of socialism, and came to it basically in a favorable way. Basically thought that basically Mises was right, although there were a few little technical objections. But one of the things I disagreed with was Mises's methodology of economics, his view that the entire corpus of economic theory is spun out from self-evident axioms without any empirical research. I take the contrary view, which is more normally associated with people like the Chicago School, which is that economics is an empirical science and its claims can be tested empirically. For example, if you want to know whether the minimum wage creates unemployment or increases unemployment, the way to do it is to run a test and look at the minimum wage in operation. And there are ways to do that statistically so that you can isolate the difference made by the minimum wage. And lo and behold, what you find is that the minimum wage does increase unemployment. To try to prove that the minimum wage will increase unemployment by sheer reasoning from first principles, well, you can maybe do that, but I think there are problems with trying to do that, and I don't think it's so convincing.
Okay, so just to be clear for our audience, this is actually the issue that we're going to be discussing today. Whether economics or more specific or more broadly, I guess, praxeology, not whether its conclusions are correct, but whether its methodology, whether the method in which it approaches the state of human action is correct or not. Just wanted to clear that up for the audience in case they're.
Right. Well, I was trying to segue.
It's like what praxeology? You fucking chiropractor? The fuck are you talking about? It's like a made up word. It's just stupid. Prax. I can't remember. What does it mean again? Oh,
your claim is that
or how you break it down linguistically,
like
or when that word came to
increases have to be empirically tested. And I guess my first question would be, what
so funny is if you could prove all this by mathematical equations,
in order to determine whether an increase in the minimum wage was effective or not.
And, run some calculations.
How would one determine whether that worked?
Brock could do this.
You mean whether it increased
data
unemployment?
analysis?
Correct.
On these
well, the way that some recent studies have done it is to look at comparable enterprises on both sides of a state border, where this one state has higher minimum wage than the neighboring state, and they are able, using sophisticated statistical techniques, to show that where the minimum wage is higher, the unemployment rate is higher too. So that would be the kind of thing I would be fully in agreement with. That is now being done by economists. That Misesians would say is a waste of time, and I presume they would say is a waste of time and doesn't get you anywhere, because you already know that by pure reasoning that a minimum wage creates unemployment.
Speaking on behalf of the praxeologists, I would say that no, it's not that analyzing that kind of information is a waste of time, right? Obviously, there's useful information. Obviously, one of the things that we believe that praxeology is good for is interpreting economic history and interpreting it correctly. So I guess if we were to look at a case of one state versus another state and their minimum wage, and we find that one state has higher unemployment, I guess the first thing is that in and of itself doesn't tell us a rule about unemployment. I mean, isn't it possible that a state could have a high minimum wage and have more employment than a state with a lower minimum wage?
Right. Well, that is, of course, why we do science, because our observations can always conflict with our theories. That's why we do it. And yeah, that's true. And that might raise a further question as to why that was. I mean, by the way, it's not just a simple matter of seeing whether the unemployment rate is higher in the state. You would use regression analysis to eliminate a lot of factors that you thought might be countervailing factors. So you would try to identify, and of course this is a fallible process, as any empirical observation is, you would try to identify the causal relationship.
And how could you be sure that your tools of measurement to identify that causal relationship are adequate?
Well, you can never be sure. It's the same in physics or chemistry or astronomy. You're never sure that your tools are adequate. But if somebody suggests that a particular tool is inadequate in a particular way, you try to improve it. I mean, the tools of measurement are fallible and can be improved in certain circumstances. And that's what goes on in science all the time. And I don't think economics is any different from physics or chemistry or astronomy.
The DNA test.
Well, I would argue that, in fact, that's not the case. And the reason that I would give just off the bat, the first thing that comes to mind is, for example, one of the things that we're talking about here is objects of action that presuppose praxeological laws. For example, a medium of exchange. We're talking about money, right?
Call me by what you normally call me by.
Money is not something like,
When we're not.
if we were talking about an increase in coins or pieces of paper that are passing from one individual to another, that in and of itself wouldn't tell us what it is that these people are acquiring, or that is what is going to achieve a higher standard of living for those people. I mean, the concept medium of exchange is a praxeological category. It only means something because we already presuppose that there is purpose behind the people that are acting to acquire it.
Well, I completely agree that in order to identify medium of exchange, you have to make a decision about people's intentions. And that money doesn't exist in isolation from people's intentions. So in order to identify what money is, you have to have a theory about what people are trying to do. And so I'm not in favor of eliminating all reference to people's assumptions and beliefs. I think that you have to use those assumptions.
And how is it that those assumptions about people's intentions, how are those observed? You know, obviously that's you just assume them and then work from there. As
well, I think in science you're always working with a theory. You have a theory about what people are doing when they perform certain transactions. Or when it is even a theoretical judgment that they are performing transactions as opposed to moving their limbs randomly. But if you see people behaving in a certain way, you classify it in a certain way, and that classification is a matter of their ascribing intentions to them.
So we agree.
That's a theory about them, just like any other theory. It's an empirically testable theory. And it's a theory that could be false. I mean, any theory in science could be false, and that's why science is so interesting, because the theory is always on trial and can always be tested against the observations. So one has a theory about what people are trying to do, and one uses that theory to make certain predictions about what they will do in certain circumstances, and then one comes along and tests whether they do in fact do what you expected.
Okay, so one of the tools in testing any theory is a unit of measurement and a language in order to interpret that unit of measurement, right? So science uses mathematics, correct?
And words as well. Yes.
And words as well. So could we agree that a theorem required to explain, some mathematical theorem required to explain some physical phenomenon could not itself be falsifiable or denied? Like, let's say if we had to talk about right triangles in some sort of physics experiment, we could agree that in and of itself is not something that we could deny. Pythagoras' theorem.
What you're getting at here is that in Euclidean geometry, the theorems follow from the axioms, follow logically from the axiom. And of course, what one can do, and what Einstein did, is one can question whether Euclidean geometry is a good description of the physical world, and whether it's a perfect description of the physical world. And it turns out that it isn't, that the world is not Euclidean, but for many purposes, it's a pretty good approximation. If you want to build a bridge, Euclid is good enough.
Well, Euclidean, like let's say something like Pythagoras' theorem, is implied in the simple concepts of things like 1 + 1 = 2. Okay.
Yes.
So
research based off of Robert Taylor's discovery of English language or his lack of understanding of it.
Why would you think I would be saying that?
because
Another
if all
Robert
the,
Taylor waste of time. See, Robert Taylor's been doing Clubhouse for a long time, much longer than what he's doing right now. And the guy he's interviewing is sitting there scratching himself saying, fuck, I don't think this guy is as smart as I thought he is. Why did I agree to this interview with this praxeologist?
I do not feel compelled.
He has an undergrad from University of San Diego in partying and chiropractic. Holy shit.
It's not about being a comeback.
But I do want to go back to their room to get their photo. If I can find it.
And other things, but we're not similar to.
Boy, man. Bullshit.
No, she.
Bullshit.
Hey, can you hear me? Hello? Hello, Diego? Come back.
His own hollow.
Him out. Oh, he's back.
Yo, so we were listening to your interview with this guy who clearly became uncomfortable with your questions, because they're not just questions, they're like statements and then questions, and your statements are so stupid. Diego, aka Robert Taylor, his debate with David Ramsey right here.
If the entire edifice of mathematics is implied within those first.
The entire edifice of mathematics. Listen to this fucking. What kind of Adderall were you on?
Conceptual ideas, then to say that one is not a good.
You were like 100 pounds lighter here too, bro. Holy shit, you have put on the pounds.
The simple thing from which all the other implications of the science stem from.
The guy's talking, he's sitting there scratching his face like, what the fuck?
Are you drawing a parallel in praxeology? Is that what you're saying?
Well, no, my goal was actually
exactly.
To say that
Are you drawing a parallel between praxeology?
Even within physics, certain tools that are used and employed, which can not be falsified. They're not. They're not.
So you are drawing a parallel between praxeology and mathematics.
I mean, there is a parallel, and I can draw it for you. If
People outside the universe refer to this as the pure light joint. It's a pure light joint, and it's very useful in economics, but it doesn't substitute for empirical investigation.
Yeah. So he was talking about regression analysis, and so what we did is we ran some regression analysis using Grok, and I'm going to now share with you what's called mathematics, or doing calculations to figure out how to optimize the blend. Is that okay? Is that okay with you, Diego?
What is it, Diego?
Do I sound different?
Yeah, you sound like you got about 100 pounds on you.
I think you sound. I think you sound sexier now, but you sound good there too.
Damn.
Like you just sound more masculine now.
This girl is not. This girl's definitely not a Muslim. When daddy passed on and went to Allah and all the virgins.
Oh.
I hope my dad has a lot of virgins. I hope that's true about heaven. That'd be great.
Wow.
I would hope that for him. That'd be great if that's actually reality. Like that would be amazing.
Wow, your poor mother. Oy vey.
Dude, what do you mean?
Dude, what do I mean? We just ran some Grok queries. What are you talking about? What do I mean, dude?
When my dad was in his post-stroke state, I would like in front of my mother. I'd be like, "Do you want me to go bring this other woman that he had that he was in love with from his village to try to see if that would bring him back to life?" And my mom was not against that. There's a rumor that he was like in love with this woman when he was like a kid, but ended up marrying my mom.
Dog's struggling with this because he's still working on just getting one woman.
Like, I know my dad had a lot of flaws and had a lot of.
No, you don't go out with a 19-year-old anymore, do you?
I'm sorry.
No, he does his own age now.
What was that, Robert?
His name is Diego.
Who does go out with a 19-year-old anymore, do you?
Don't go out with
He wants to leave
19-year-olds
them.
anymore. Do you know any 19-year-olds that want to go out with a 42-year-old bald guy who's unemployed? I mean, hello?
No, they just wanted to go out with
for the record, I think I've known you since you were, 37? And, you haven't changed. It's still the same.
Well, that's the thing about a bald man. A bald man can't look like he's going through cancer. It looks like he already beat cancer.
Look at it like this way. You don't have a gash in your face, music.
That's right, Scarface. Good point. This face is still pristine. I don't run around through glass windows and doors like other people. My dad did that once. He went to a McDonald's and they put in new glass windows, and he walked right through the window and he cut his leg wide open really bad.
Oh man.
I was like, too bad we didn't have a lawyer in the family. We could have gotten the $1 million settlement out of McDonald's Corporation.
But Diego, why is music trying to go through your alleged stuff like that? Might or might not be you. He doesn't know if that's you.
Okay. We're destined to meet again.
And here we are right now on a conference call.
Music, you're gonna meet Diego again more than I'm gonna meet Diego again.
Well, you can live in La La Land, and that's your fairy world where you waste all your time every day on a conference call app. But that's your choice. It's like
I'm very close to getting over my injury.
I call it a prison. But I don't know. That's just my opinion. This is a cell. Like a prison. You're using your cell to be here right now. It's like a prison. Diego is your. What do they call the warden in the prison? Is it a warden? Yes, warden.
Is that what? Diego, are you my warden?
Yeah, and I want to do the Jailhouse Rock.
That's right.
There we go.
He thinks he's Elvis.
Listen, John.
I mean, have you seen his lips?
I needed money because I had none.
Keep singing that song to yourself in the Jailhouse Rock.
Or know anyone dealing.
You're supposed to give me the other refrain.
You guys need to learn how to have more fun. That's your problem. You guys are so uptight about everything.
You think so?
Yeah,
You think we're not cutting loose?
Oh no, you guys are so far from fun.
Hell no.
You still active on Instagram, John?
Yep.
Those are the 14 accounts that I was saying to follow. He has 14 accounts to follow.
Does he X or no? X, he doesn't X.
Kidding me?
He's on X too.
Tons of X
He doesn't
accounts.
X on TikTok?
Not TikTok, just X.
No, I'm on TikTok. What the fuck are you talking? I got like 6 TikTok accounts. Fucking answer for me. Robert Taylor can hear it straight from the horse's mouth. You fucking, you're a good secretary. You always want to get in the middle of everything, and therefore Robert Taylor's office never does any business because you're always running your mouth. You just take your notes, sit in the corner, and you'll get your Christmas bonus.
What's my Christmas bonus?
I don't know, 5 more years of suffering.
Oh,
But
I really wish. Never mind. Yeah, I can't go back in time, so whatever.
It's true. You can't
But
reverse
technically-
engineer
I'm
Scarface.
telling her.
Why can't I go back in time if miracles can happen? Why is that not possible?
Why can't you go back in time unless miracles
Yeah.
happen? Well,
yeah, if
because
miracles are real, why can't I go back in time? And what were you telling me, Diego? You were telling music. You were telling me what?
well, let me answer that question for you, Scarface, very very succinctly and quickly, because the now is all there is. It's called a compression. And in data packets, with these large data centers and everything, it's about compression of information, just like the original zip files. And so, thus, your subjective statement there of why can't I go back in time and miracles are real is like,
I believe I can go back.
it's like a kindergartner, who not only has, a very severe facial wound, but what you might call Down syndrome, brain damage.
Oh, okay, thank you very much. And Diego, what is it that you wanted to say? Because I knew it said this, so go ahead. Go on and say it.
Hello?
I've been trying to explain to Nora that, like you, John, there's just no sense of urgency.
I agree. This girl lacks any sense. But see, that could be because she's fearless. Maybe not only did she scar her face, but like sometimes when people get hit in the head very hard and they have a traumatic brain injury, it actually gets the fear out of their soul, out of their consciousness.
Hold on.
Is that what's happened here? Now that you've actually failed in a jihadist elevator terrorist attack, you're like fearless because you feel like you've already had an ego death? Like what's happening here? Hello?
It definitely was an ego death, and I got a double ego death when my face was
Double. You might get a triple one coming up. Look out.
But Diego, a sense
Every
of
cat's got
urgency
10
for
lives,
what?
right? Hello?
But a sense of urgency for what?
For life.
Get busy living or get busy dying.
Yeah, exactly.
Okay, get busy living doing what?
Love.
Working?
Scarface, you have ears. Try to use those, not your lips. And use your nostril holes, but not your lips. Now listen very close. Hello?
Relax. Like, what is living? Like, living is not working.
Are you heartbroken or are you a heartbreaker? That's what it comes down to. Those are the two do's in life. Heartbreaking and heartbroken. Which one are you? Hello?
I don't think it's that dichotomy.
Just say it out loud. Heartbreaker. Go ahead. This is called English training. Heartbreaker. Say it out loud.
Heartbreaker. You get the
Heartbreaker or heartbroken.
Okay,
There you go. That's my toy portion for the day. You may go back to your brain rot spam.
But really, Diego, you're saying get no sense of urgency. Like I said in the context yesterday of his wife getting married, having children, and they're like being happy, not being tortured. Like, okay, if I work because I need money and I need to okay, I'm working. Is that really living? Is that really a sense of urgency?
Hello?
I just don't understand the concept of the sense of urgency.
Hello? Go look up the word and read the word out loud. Do you need a definition for the word urgency? It's called swiftness.
So now hearing that,
for example,
the press,
I think
so to speak, has potentially jeopardized the public's ability to maybe hear this hearing and, jeopardize the transparency of all of this when it's already been,
You know how people, for example, women when they're gonna turn 30 have a sense of urgency because their fertility window is closing. For example,
the jury pool and the public opinion.
I hear you. And so when I turned 30, I didn't think twice about anything. I was like,
what, Nazi?
The order.
Yeah, the judge is back speaking again.
I know that. Are you gonna play it or?
Oh, I didn't know if you wanted to. I will.
Husband. But in responses, but I'll hear brief argument, and then we can go from there, Mr. Ballard. Thank you, Your Honor. With respect to this motion, I think as we've expressed in the past, everyone in this room shares the same, and that is to ensure that there's a fair trial that happens in this case. And we recognize that the court's pretrial publicity order was
is intended to further that goal. And again, as I've stated before, the state plans to try this case once. The state is also committed to complying with its ethical duties with respect to pretrial publicity. We have complied with those duties. We will continue to comply with those duties. The issue we bring before the court here is that there's one portion of the pretrial publicity order that can be interpreted to reach beyond those ethical requirements and have the effect of being what would be an unlawful order, an unlawful prior restraint on speech. And our goal, therefore, is to get an order that's clear, that's lawful, and that the state has the ability to comply with. And the issue with the order that the state has is the use of the term witnesses in the order. We believe that term's vague and ambiguous. Does it mean anyone with relevant information about this case? Does it just mean those people that are going to be subpoenaed to testify in this case? Or is it limited to just the prosecution team? And I think as we've expressed in our filings, we believe that the court intended that that term just be limited to the prosecution team, because that is the way that Rule 3.8 reads. Rule 3.8 of the Rules of Professional Conduct that deals specifically with requirements for prosecutors talks about investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor. So in other words, the prosecution team. And there's no rule or case law or statute that expands the prosecution's duties beyond that group, the prosecution team. So with respect to clarity, we're seeking clarity as to what exactly does the court mean by witnesses. And we think the court just means the prosecution team, because if that term stretches beyond just the prosecution team, then the order is written, we don't believe is a valid and lawful order, because it would result in a prior restraint on certain speech, and at the very least would have a chilling effect on that speech. If the prosecution agrees, we have an ethical duty to take reasonable measures to make sure that those who are identified with the prosecution team are alerted to the requirements of the court's order, and to make sure that they do not make a statement that the prosecutors themselves would not be able to make a public statement. But if the order extends beyond that, then we have concerns, because a prior restraint is an order that forbids certain communications in advance of the time that they are to occur. And as the Court of Appeals has recognized, the Utah Court of Appeals has recognized in State versus LM. And widespread publicity in a case does not justify a prior restraint. As the United States Supreme Court has recognized in Nebraska Press Association, there's no justification for a prior restraint unless it's clear that the further publicity, unchecked, would so distort the views of potential jurors that you couldn't find 12 jurors who could be fair and impartial. That's the high standard that applies in this case. And so in order to apply a prior restraint to persons beyond the prosecution team, the court would need to engage in a very detailed and demanding analysis. The court would have to make a factual finding of necessity that the speech that would be restrained poses a risk of material prejudice to the ongoing judicial proceedings. The court would need to make findings that there are no less restrictive measures, and that the prohibitions are likely to prevent the potential prejudice, and that whatever prohibitions this court decides on are very narrowly tailored. And as the state has explained, the Spencer versus State case from the Arkansas Supreme Court that just issued earlier this year is very helpful, I think, on this issue in explaining the analysis that applies to various different people that might be associated with the criminal case. You have attorneys, that category of trial participants. Certainly the court has the highest degree of ability to be able to restrain the speech of attorneys, and in fact, as I've expressed, the ethical rules require that. But when it comes to trial participants, like witnesses, the standards are more demanding as far as restricting the speech of trial participants. And as the Spencer case pointed out, non-attorney trial participants, the court can impose a restraint on their speech only to the extent that the court first finds that any speech by those non-attorney trial participants poses a serious and imminent threat of material prejudice to the ongoing proceeding. And I think the court also needs to note that there are several people associated with this case who have very significant interests in exercising their First Amendment rights in talking about how this case has affected them. And of course, can't say this, one person's First Amendment right is more important than another person's, but there are certainly some people here who have a larger, some people involved who have a larger or a greater interest in speaking than others. And so I think the court needs to take that into consideration if this order is meant to apply beyond just the prosecution team. And then finally, as far as making the order, so we need a clear order, we need a lawful order, and then we need an order that the state can actually comply with. And the state recognizes that there are serious sanctions that this court can impose for violations of a court order, as we've just seen. And so we want to avoid these. We want to avoid the litigation over whether there's been a violation of the order. And as it stands right now, we don't believe that there will be any issues if the court limits the term witnesses to just the prosecution team. We can comply with that order. It gets more difficult for the state if the term witnesses then applies even broader at this stage of the litigation for the state to be able to comply with that order, depending on how the court clarifies what witnesses mean. Does the court have any questions for the state?
No, thank you. Thank you, Alder. Mr. Novak.
Thank you.
I'm going to try to be brief because our views on the propriety of the court's order were set forth in a publicly filed document, which, of course, the court has reviewed. And the first thing that I want to say is that the order that the court issued is not a prior restraint on any member of the public, and it's certainly not, I think as the state's motion suggested, some sort of a prior restraint on the press. This has nothing to do with the press. The order, as we noted in our papers, is directed at the conduct of and the court's expectations for counsel. So even if under that order that the court issued, somebody who we could all agree is a witness within the court's definition of that, made public statements which implicated Mr. Robinson's fair trial rights, the potential sanction is on the party who had a duty to make a reasonable effort to notify witnesses that they should not be doing so. If I represented a witness who was accused of saying too much publicly, the first thing thing that I would tell this court is the order isn't directed at the witness. The order is directed at the counsel for the parties. There may in the future be some theoretical situation where the court issues orders that control the statements or conduct of specific people, but this, or other than counsel, but this directed at counsel. And we have no, meaning Mr. Robinson's defense counsel, have no problem complying with the order. And we also think that we understand what a witness is when the court uses that term. So it is our view that the court's order is not overbroad, it's not vague, doesn't put the state or the state's attorneys in some untenable position. And I think it's a little too simple to say witnesses are either everybody under the sun or people who are subpoenaed at the last second. Because counsel have not only the training, but a duty to figure out along the way who the potential witnesses are and to notify those people. And yes, down the road, maybe there's going to be an issue and maybe an attorney on either side of litigation is going to have to explain to the court when a particular person did or did not become a potential witness in the eyes of that party. That doesn't make it impossible for the state to comply with the order. It just means that the state needs to be thinking along the way about who its witnesses may be. And that's why in our papers we refer to it as a potential lay witness, because we believe that the court intended it to go beyond members of the prosecution team, which are law enforcement officers, retained experts, retained consultants, and we don't believe that that creates an enforcement problem. We don't think it creates a compliance problem. We noted in our papers, and I'll emphasize here again, that the court's order actually places responsibilities on defense counsel that the rules don't. The rules have special guidelines for the prosecution, and the court has expanded that to include the defense, and we don't have a problem with that. I also think that the standard that the state is suggesting for when a potential lay witness, as we've defined that in our papers, may make public statements that violate the court's order. The best standard is actually the one that we believe the court should look to, which is the standard set by the 10th Circuit, because as the state points out, it may be that there isn't any Utah law on this issue. So it seems to me that the closest source of authority on this constitutional question is going to be the 10th Circuit, and that's the case United States versus Tijerina, and I'll spell it as Tijerina, 412 Fed Second 661, 10th Circuit, 1969, where the court says that the constitutional balance between the First Amendment rights of a non-attorney participant and the defendant's right to a fair trial are properly balanced where extrajudicial statements present a reasonable likelihood of prejudicing a fair trial. That is a more protective standard than that which appears in Rule 3.6. We think it's the appropriate standard which should be applied here. And that's part of, as we've told the court before, a motion that we will bring, because we actually think that while the court's order is wholly appropriate, it's not vague, it's not overbroad, it's not a prior restraint, it doesn't create a lack of clarity for the state. We would like it to be a little bit broader in other areas, especially concerning the standard to be applied and the definition of what is the prosecution team, but that's not germane to here. So we think that while we understand the state's concerned. We think that their motion should be denied. I think at the last hearing, the court actually clarified verbally from the bench what it meant by witness. And I think that's pretty close to what we described in our papers as a potential lay witness. So I feel like if I say anything more, I'm going to be reiterating again what's already in our papers. If I've muddled it, I'm sure the court will tell me and I'll clarify it, but I hope I haven't. Thank you, Mr. Novak. Okay, thank you. All right, and we'll turn to the last matter. Anything further, Council? Yes, thank you, Your Honor. I do want to point out that the court's order, as it's written, does impose limitations on speech. And the issue here is whose speech? Is it just the prosecution team members, or does it extend beyond that? And limitations on speech are a prior restraint. The court's order says that, if you look at page 2 of the order, it specifically talks about lawyers, that lawyers cannot make a statement that would violate Rule 3.6 and need to inform witnesses that they cannot make similar statements, and it requires the parties to inform lawyers, I'll just read it. Lawyers participating in the investigation or litigation of this case shall inform all witnesses, and then the list that I read about the prohibitions contained in this order. So the order is prohibiting speech, and because if it extends beyond the prosecution team, it needs to have the findings that are required for that kind of prohibition on speech. That's what we're asking the court to do. Thank you, Mr. Bell. Thank you. All right. Let's turn to the final matter before this court, the motion for limited intervention and request for notice of motions to close, seal, or reclassify. And I'll hear from the parties on that. Thank you, Your Honor. David Ryman, representing the news media, Mr. Judd, and I represent different groups of clients, so if I miss anything to weigh in after I'm done, but my intent, the issue of the basis is same, so my intent is to address them for all of the interveners at once, and I'll be very brief. We have only ever sought, in this case, limited party status. That is what we do in every high-profile case that involves these type of closure issues. We are not seeking to be parties for all purposes. We are just seeking to be parties for the purpose of showing up and being heard, which we unquestionably have a right to do. We unquestionably have standing that is settled on Utah. And the last filing, at least, that we got from Mr. Robinson's team that just came in, I don't know if it was a couple days ago, basically gets there at the end where it says, look, if you're going to grant them intervener status, it should just be limited. That's all we've ever sought. And so the question that was raised in the only case that they cite, this FL case from the Utah Supreme Court, that addressed whether we wanted to allow full party status under Rule 24 of the Civil Procedure Rules in a criminal case. They said we don't need to do that. The woman in that case just needed limited party status. So in a way, we're not really really has to disagree with this either, but we're not really disagreeing with Mr. Robinson's team. We have explained in our papers that we cited the court to extensive authority saying that this is the procedure to use. It's the most efficient procedure to use. Otherwise, I don't know what exactly the suggestion is for Mr. Robinson's team that we're supposed to do from here on out. It kind of sounds like it's just this sort of ad hoc show up anytime you happen to see something on a public document that might affect the public's rights, and that's just not. I think that Robert Taylor, or whatever his name is, and the others that mentioned in our papers, the one who was like that allows for the media to be able to be at the elevator appeal, closure issue, wild, without having to rely on courts for like displaying like their pseudo online relationships online and stuff like that. In either Carnes Tribune or Bullock, where the media was not granted party status.
Not sure what you said. I couldn't hear the whole thing you said. Not sure who you're talking about. If you can say it again.
To review her claim regarding records under extraordinary jurisdiction rather than
Oh, you think they're fetishizing their relationship?
Yeah, they're fetishizing like their pseudo relationship online.
Yeah, for sure. They've used me to record them for a long time. So like I am the circuit in their dopamine feedback loop. They may be filming it themselves now, but who knows? It's just it's their show, you know. I've conditioned them a lot though.
That was so hilarious when you did that happy hair. I love that. That was great.
What we're requesting is under Rule 24. Rule 24 is in the civil
That's a
procedure
really
rules,
good
but Rule
hypnosis.
81, and particularly subsection F of that rule, is that the rules of civil procedure govern in criminal proceedings where they don't conflict with a rule of criminal procedure. That's the case with Rule 24. That's why courts in criminal cases have relied on that rule. The other one is Rule 31, that's in the criminal procedure rules, and that gives this court the discretion, if it's not inconsistent with the rules, to fashion remedies and to deal with civil procedure, not civil procedure, but rather as procedural matters. And so that is essentially what happened in the FL case, which is that, whether you do it under Rule 24, whether you do it as a judicially created, remedy, doesn't matter. It gets to the same place, which is just that we are interveners for the very limited purposes that we've set forth in our order. We're not going to be here at every hearing arguing. We didn't take a position on the gag order motion that you just heard. We are only planning to appear and argue so that the court has the benefit of someone who's representing the interests against closure. Because as you know, and this is sort of why
Is that Mountain Man?
a lot of times this just happens by stipulation.
It's a Mountain Time!
To say it in
Get up here, Mountain Man!
They may not want to fight over a particular issue, and so it really is a situation where no one really.
Welcome to the room, Mountain Man! We're listening to the Tyler Robinson, Charlie Kirk assassination trial.
Unless the court has any questions, that's all I have.
Yeah, thank you. What did it seem like? Does he,
To the state, Mr. Bellick. Your Honors, as the state briefed in briefing on prior motion, I think it's clear that parties have outside entities have the ability to intervene in a case as a limited purpose party when there's a statute, a rule, or case law that authorizes them to take specific action in a proceeding. And there's well-established case law that allows the media to intervene, to be able to appear and be heard on matters of public access to court proceedings and to court documents. And Rule 4-202.04 of the Rules of Judicial Administration also make it clear that the media can appear and do.
Never had one lesson there, Mountain Man.
That we held earlier. So it doesn't make them a.
Man, Mountain Man knows what he's talking about. Mountain Man, I want to put you in charge of Southern Command. You're going to take care of the war, Mountain Man. You a leader amongst your people on Clown House Mountain Man. Subject matter expert extraordinaire. Booty hole picker. French flicker.
So I just want to clarify the issue, really, if we boil it down, is if these 23 media entities have met their burden to be a limited purpose party in this case. And I think another part of that is what that means. And really that is what we are primarily concerned with. What does that mean? What does that enable them to do? What jurisdiction is this court exercising over them as a result of them being a limited purpose party? Because I do believe that is another aspect of asking to intervene in a case. I do think that Rule 24 does not apply here. I think that's from the Supreme Court. They don't want individuals using Rule 24 of the Rules of Civil Procedure because it's too expansive. It's about broad entry into a case for many purposes. In the instances where our courts have allowed intervention into civil cases, and I want to be very clear here, the case law is in the civil arena. There are very few instances where we're dealing with this in a criminal case on appeal.
It's called the Constitution, you stupid twat!
But I would ask the court to be very clear, no matter what it does, on what the media can and can't do in this case. And it sounds to me like the media has somewhat conceded that their role in this case is under Rule 4-202.
They conceded?
And
Bitch, that's your opinion!
is to have a voice regarding closure, which has already happened today and will surely happen again. We have no objection to that. And to be clear, we're not objecting to the court's order about notice. We will provide notice. We will follow the court's order. We have no problem with it. But we do want this to make
there's no buts.
Very crystal clear. We want time frames. We want orders saying this is when you need to respond so that we don't end up with filings like we did this week, very shortly before the hearing, that we have to rush to respond to. We're all attorneys. We all know that these things happen from time to time. And we're not unreasonable folks.
We all
Reach
know
out to
it.
us. We will grant reasonable requests for extension, just so everyone is aware. But there was no communication. So
Well, this is it right now.
very clear what they can and can't do. It's less about semantics. This isn't about semantics. It's about substance.
Semantics,
What are
not
they allowed to do?
subjective versus objective.